Ladies and gentlemen, we're going to go ahead and get underway. Richard will be joining us as soon as he gets off a work call. Being a faculty member, I have no idea what he's even referring to. Work call.
It's like a committee meeting.
He didn't have my phone. Nobody doesn't have this phone number. Well, I will delay and tread water here a little bit by introducing our moderator, Eric Greenwald, my colleague here at the Strauss Center at the University of Texas. Clearly the most distinguished position he's had, but here's some other things he's done. And the National Security Council staff, Eric most recently was Senior Director for Cybersecurity. Before that, he was with the FBI's National Cyber Investigative Joint Task Force, where he was Principal Deputy Director. Before that, Deputy Director of Operations at some place called U.S. Cyber Command. And before that, Chief Counsel to some entity called the House Permanent Select Committee on Intelligence. I don't know what he's been doing with his career, but now he's in academia, so he's okay. Eric, the table is yours.
Thank you very much. This panel, as you know, is on the topic of active defense, and before we get started, I just want to make sure we clarify the term hackback gets used a lot, and I think that to the extent we're talking about measures that private citizens and companies might be taking to defend themselves on the interwebs, that we're really talking active defense is a much more appropriate label, because although we may have some disagreement, that for the most part we're not talking about efforts to retaliate, damage, destroy. Even when you discover somebody who's perpetrating a crime against your computer, your network, we're talking about efforts to defend against the commission of crime. But I think we'll have an opportunity to define and narrow that through the discussion, and we're of course open to contrary viewpoints on that. Since Stuart Baker is not here, I will have to channel him a little bit, but I think we'll have the opportunity for an interesting discussion. Let me just briefly walk through our panel participants. I think you've got their bios in the materials, but so that you understand where they're coming from, what their expertise and perspective is. We have Andrew Woods from the University of Kentucky, Paul Ohm, who used to be at the Department of Justice Computer Crime and Intellectual Property section, is now at Georgetown University. Richard Dowling, DOJ, longtime CSIPs, and then Christian Beckner, who was previously with the Senate Homeland Security and Government Affairs Committee, is now with George Washington University, where he's actually heading up a project that's specifically looking at the question of active defense. So hopefully we'll have some interesting perspectives from that. I had intended to start the panel off by asking Richard specifically what he thought the role of government ought to be with respect to defending private individuals and entities from cybercrime. Since he's not here, I think I'd like to throw it open to the rest of the panel, unless that's not Richard. But before I do, I just want to say the format for this particular panel is meant to be just discussion. We don't have set piece performance presentations, and so really you all should feel free to start jumping in with questions right away. So essentially the Q&A session has already begun. But with that, let me see if any of my panel participants would like to. Yeah, Andrew, go ahead.
Yeah, so I have a thought here, actually. It seems to me active defense is such a broad and vague term that not only do we, if we're going to talk about it, need to clarify what we might mean by it, but I think as to what the government's role could be, it seems to me the first most important step the government could provide is to just clarify what existing law means in this space. And that's not a vague statement by DOJ about what the CFAA or CISA allows. It's a really detailed look at what are the various options under the heading of active defense, and then clarification about where they fall under the law. So just as a brief example of things that all go by the heading of active defense, blocking the intruder, disabling the intruder, wasting the intruder's time, giving the intruder files that might be beacons, giving the intruder bogus files, giving the intruder reasons to look in the wrong place, studying the behavior of the intruder, tracking the intruder, and then calling the cops. That stuff is all clearly okay, and it's all active defense. And then there's a bunch of other stuff that's maybe okay, maybe not okay, that's also still called active defense, like turning the intruder, changing the code of the intruder in a way that that maybe affects their systems. Now, the CISA, which was meant to clarify some of this, says you can't disable destroy or harm their systems, right, substantially harm their systems. But what does that mean? So so the first thing I would want from the government is it's not more action in this space or less action or delegating to the private sector, but just clarity about what the rules are and how they apply to the various things that people call active defense.
So my sense, based upon both specific past practice in this area and also the Department of Justice propensities when issuing guidance generally, is that they would come back in response to that with something that was, number one, quite conservative,
Yeah.
and number two, to the extent it was clear, not necessarily illuminating.
Yeah.
And I think we've seen. Sorry. I think that we've seen this with respect to the DOJ has issued guidance related to defensive measures that people can take, and the line that they've basically drawn is if it's outside your network, don't do it.
Right.
And I guess the question I would ask is what. And everything that you described, all the measures you described, unless I missed something, is all stuff that people would do inside their own network. It's something where the adversary could be pulling, having something done to his efforts inside an opposing inside their target network and pulling it back to their own. But is there anything that you see as within the confines of existing law that people could do outside of their networks?
Well, how does it? I mean, so how do government guidelines? First of all, I would say you're doing a great job playing Stuart Baker. Second of all, how does the government feel about so what does it mean inside your network? What if you ex ante devise a file that once it leaves your network does all kinds of things? That's something I did inside my network, and they carried it outside my network. But as I read the existing law, you could do something inside your network that violates the CFAA and CISA.
Well, but you put beacon on your list as clearly legal. Mm-hmm. But as I understand the way most of these beacons are going to work, aren't they going to operate exactly as you just described?
Well, it depends.
They're going to run code on the other processor, aren't they?
Yeah. So they're more clearly more problematic under CFAA and not under CISA, as I understand the laws. Right. But again, because as long as they're not doing harm, all they're doing is sending a signal about their location. Right. But there's also this question of whether. Well, I don't know. You want to?
Well, I think one thing I want to make sure we look at is, and hopefully when Richard gets here, we can talk a little bit specifically about what is the responsibility that we should expect government to take for defending private sector entities and individuals in cyberspace. I don't know if anybody wants to tackle that specifically. We can wait until Richard gets in here too. But if whether we can look at it as a national defense model where their only real responsibility is defense crises, attacks of nation states, or we could take a public health approach where it's issue guidance, intervene when there's a pandemic. I don't know if you folks have any thoughts on how we should think about what we should expect from the government in this space.
I mean, I get at that, and thank you to Bobby and everyone for having me here. Hackback is not something I've ever written about, and probably haven't even thought much about since my days as a CSIP's prosecutor. So maybe I wear that government hat a little bit more. I mean, I think of your question in reverse, which is what are the things that corporations might want to do that more appropriately seem to me to be the role of the government? Mm-hmm. So where is the gap coming from the other side? Instead of how would we push government down, what are attempts to push corporations up? And it seems like, and please correct me if I'm missing nuance in the debate, it seems like so much of this debate, particularly from those who are suspicious of granting broad immunities for things we might call active defense, it seems like the primary argument is the unintended consequences, the innocent third parties. And to me, that's important, but it's far less important than lots of other things we would want when we're talking about something that frankly feels like warfare a lot, right? Things like accountability, transparency, respect for civil liberties, respect for something other than the profit motives of a large corporation, right? In other words, kind of what are the things we demand societal responses to as opposed to individual market responses to. That's where I think there's a gap, and that's where it makes me really nervous, irrespective of the law. I'm talking about the policy question here, to tell a bunch of cowboys at a bunch of companies, go with God, we have lots of faith in you. Instead, I'd want the government to play a strong, guiding, coordinated role, and I think the CFAA actually invites the government to do exactly that, right? And so my answer would be thick government in a lot of this is what's needed, and we can talk more about how we would bring that about, right?
So let me pose the question this way: if we try to apply physical security as a parallel, and there are all sorts of ways in which that parallel breaks down,
Right.
but the government it does not have the resources, and frankly, we don't have the expectation that they will be everywhere to stop every kind of crime. In the realm of physical security, there are lots of mechanisms available for people to defend themselves. And whether this is the actual tools to do it, but I'm talking more about if not legal authorities, the legal theories that they can apply to, like self-defense, either baked into a statute, or common law concepts of self-defense. And I guess a question I would ask the three of you is, do you believe that there is or should be common law defense available for violations of the CFAA?
So I don't think there is, right? I mean, one thing that I have found fascinating about this debate is I love that we're going to talk about Stuart Baker the entire hour.
We'll move on.
But no. I'm gonna do this in a way that's going to invite Stuart to respond to me.
He might be watching the live stream.
He wrote a series of very, very, very superficially reasoned CFAA blog posts 3 years ago, and somehow that has led other people to say, well, scholars disagree on the correct interpretation. I don't think scholars disagree on the correct interpretation of the CFAA. I reread some of those blog posts the other day, and had a student written that in my computer crime class, I probably would have given them a C or maybe a C+. And I think he conceded that this is his debate with Professor Kerr.
Yeah.
I think he conceded it by the end. He shifted quickly to, well, it ought to be the law as opposed to it is the law. Now, maybe the Supreme Court will surprise us and create a rich body of common law defenses based on self-protection or something else. But it would be a stretch, right? And of course, isn't the question really, should the general counsels of this country begin telling their staff that, yes, this is our strategy, right? We're doing the moonshot. We're going to get self-defense baked into the CFA someday, and it's going to cost a lot of money, but we're the ones to do it. That's the slightly more practical question. I think the answer to that is I wouldn't do that if I were a general counsel of a big company. I'd be surprised if there were a lot of general counsels giving that. Maybe there are. I don't know, giving that advice.
Yeah, but here's something that you would do if you were a young lawyer at a law firm trying to build a book of business.
Yeah.
Knowing that if you say the word cyber, you can bill twice as much and you have 3 times as many customers.
Right.
You would take Stuart Baker's proclamation and say to your clients who very much want to, they're scared about cyber stuff. You can build them an awful lot that on the premise that they can look into being more assertive. And I get the sense when I talk to cybersecurity companies who are in the hackback active defense space that it was much more about marketing and posture than actual action, and they were making an awful lot of money marketing themselves as hacking back. And I think Stuart Baker is built a lot of business around a position that's not a statement of current law, but sort of an aspirational statement and maybe a marketing statement. So markets seem to me to be as relevant to this analysis as the law, and I actually think I was chatting with Richard, our friend from Microsoft, last night about this, and he brought up an interesting example. I mean, even if your general counsel says it's okay to respond to something or to be super aggressive about pushing out some defense to every machine that runs our code, the risk is so high that you mess something up. I mean, you could push something out to a life support machine and disable it, and that's a much bigger concern from the general counsel's perspective than could be a bigger concern than responding to the attacks. So I think keeping track. There's the division between markets, laws, and norms. The debate is very much about the law, but I think the markets and norms pieces are just as important.
Sorry, go ahead, Chris.
Yeah, and I think, when you mentioned, that there is this market for this, I mean, I've been in a number of meetings where people in the private sector, not the people in the general counsel's office or even the CISOs, but people running business lines or who have been affected by DDoS attacks or other significant attacks, or their attitude is, why can't we do more? We're just sitting here defenseless. The government's not helping us other than the occasional threat bulletin. So that's the, sort of, the thread that we're trying to weave in this project, and we're early on in it and don't have the answers, or the framework yet. Hopefully this meeting is something that'll help in that process. But, there clearly is a gap between, what companies feel they in a lot of cases they would like to do and what they're able to do, and how do you make sure that companies don't take action that goes beyond the law, that gets in trouble, that then sets the precedent for what other companies can do going forward too restrictively, so that some of these measures within companies' own networks become less acceptable in terms of active defense measures.
I think that the notion of the three different pillars of how you build any regime, one of which is the market, is an interesting concept. I wonder, I know I have heard people make the argument that the law allows so much and law enforcement provides so much, and that there's a gap, and essentially there's a gap that the market could fill but is not allowed to because it's against the law. And I guess the question is, are we in a place where there's enough harm coming from cybercrime that the government is not capable of stopping, and that that the private sector is not enabled to stop, where we need to do something, where we need some form of change?
Yeah. It's just really hard to answer that question, because a lot of it's happening, if anything's happening, it's happening quietly in the dark. And the people who claim to have the answers are the people who will make a lot of money if you let them go forward with this. And so the incentives are totally skewed. I mean, Jennifer and I were on a panel at RSA a couple of years ago on this very topic, and the people who were really pro hackbacks were the people who had just launched companies with very high valuations to do hackbacks. And so, it's like, how much do you credit the argument that that's going to solve the world's problems?
So part of the way to address this gap, and one of the things we had talked about in advance, is sort of to broaden the definition of active defense, even beyond the countermeasures discussion, to issues like public-private partnership, issues like incentives, issues, and so.
Well, and that's consistent with the first thing I said, right?
Yeah.
So if the government, when I say the government should play a thicker role, which only academics call that thicker, sorry about that. When I say that, what I mean is it doesn't have to mean armies of government-trained techies, right? It could just mean using the 1030F exception in a way to deputize people in official government investigations, or whatever the magic language is, right? In ways where we get we fill the gap that I identified, the due process gap, the accountability gap, all of that stuff will come from the government role, but it's still, at the end of the day, going to be kind of a commissioned, deputized private team that's doing it, as opposed to whatever gun for hire. I love the Old West metaphors, right, that are rich here. I'd rather not go directly to that much of a frontier model. I still want the strong sheriff running the show.
Yeah,
right?
no, and one of the models that we've been looking at so far is, the examples from some of the botnet takedowns is an example of good partnership between federal law enforcement agencies.
Why don't we talk about botnets for half an hour and just totally supplant the next panel? No, I'm just kidding.
We can consolidate.
Yeah. Well, so I guess, what do you think about the notion that if we're talking about actions that you might take outside of your own network, because I've heard from a couple of you the notion that if you allow companies latitude to take defensive measures outside of their own networks, you run risks of them, disrupting networks unintentionally, or we haven't talked about it, but creating international incidents. Do you see a distinction that can be drawn between measures that are literally defensive in nature, where you're trying to stop a criminal or a suspected criminal from doing something, stealing your information, damaging your system, and activities that are much more about information gathering, where your activity outside your network is designed to try to identify the perpetrator so that you can either hand that information over to law enforcement or avail yourself of one of the civil remedies under the CFA or other statutes. Is that a distinction that can be drawn in a way that might actually get us somewhere, or is it too murky an area?
Yeah, I'm not sure it clarifies things terribly, but I actually like the CISA language of focusing on the harm. If the outcome that we're trying to prevent is in the Wild West shootout where innocent civilians are getting shot, just say you can't be shooting innocent civilians. That's the thing you can't do. It's strict liability, and then the question is, what can you do? Again, more guidance would be really helpful. It seems to me I don't have enough information about, it kind of depends on the company and industry. If you talk to people at one company, they say, truthfully, our goal is to be a little bit better than our competitor. It's not to stop these things completely, and we don't want to there's so many risks involved in going out there and actually doing anything aggressive. It's just, if you're Costco, you want to beat Sam's Club. It's like, it's all relative to what they're doing. And so it's, and there's obviously this cover your ass syndrome where you want to pay a little bit more for the slightly better consultant so that you can say to your board that you did a slightly better job than your competitor. I think you want both to be strong on defense within the network, but also seeking information about attacks. Those are both seem like reasonable, responsible, non-harmful activities.
So I'm not sure I understand at the end of the day, your answer to the question, that these are reasonable activities that people can and should undertake, or only when doing so through, whether it's the 1030F exception or something like that?
You're saying seek out information that
Yeah.
doesn't harm anybody by you seeking it out about threats to your network? I think that's totally fine.
You think that's fine?
Yeah.
Okay. And you could argue, the CISA language does separate defensive actions from monitoring.
Yeah.
But it still requires consent.
Right.
So I guess the issue is, it's now instead of the CFAA, we're talking about the Wiretap Act or
Right.
the Stored Communications Act.
Right.
And those don't, they certainly don't have a self-defense exception.
Right.
And so I guess we start getting back to a question of prosecutorial discretion. But
Yeah.
I'm interested in thoughts from the
Well, I mean,
audience.
even in that last exchange, right? Your question was, and I'm going to have trouble rephrasing exactly. You're going out and actively gathering information. I mean, that could mean 1,000 different things.
Yeah.
From, I guess it's so commonplace to say this, but there's such a spectrum here on everything. And so I think at the end of the day, this panel is going to agree there are lots of things you can do, and there's a lot of things you can't do, and often the line between it is quite fuzzy. But the very first part of that three-part thing is really important. There are a lot of things you can do, right? And so I think it confuses the debate to say DOJ has muddied the water, prosecutorial discretion is not good enough because we're just in a cloud of uncertainty. No, if I'm a lawyer and I'm sitting down across the table with a techie, and by the way, if I'm techie enough to understand what they're telling me and not credulous to every single claim they're making, we're going to walk out of that meeting with a long list of things they can do, right? And we're going to have one column which is, you can do this stuff, and I guarantee you, we're not going to be liable. Probably a longer list that says, you can do this stuff, and who knows, we might be liable, but no one in their right mind is ever going to prosecute it for us. And then you're going to continue to add columns after that. But if we understand that that is the baseline, like the baseline is go with God, you've got a lot of freedom here, then we're talking about, in this debate, the stuff over here, which is all fairly aggressive, and frankly probably wouldn't be used that often. I don't know. There's a lot of empirical claims I'm making here that I can't back up with data, right?
That's for academics.
But I'm an academic. I don't need to. But it seems like I wonder if this is a really narrow set of circumstances where the difference here is really going to matter much, right? I don't know.
And the next thing I was going to pose to the panel is the scenario that is, in the same way that people who talk about, enhanced interrogation techniques throw out the ticking time bomb scenario.
Yeah.
There's a popular scenario in this context as well, and that is you're a company, you either are already being raided by some malicious cyber actor, or you see it about to happen. You turn to your friends at the FBI or your local police, and you try to get some help, and they simply don't either have the resources at all, or at least the time to turn the resources in your direction to where they're actually going to be able to stop the attack. And I think Paul would go back to what the columns you were delineating.
Yeah.
Sure, there's plenty of stuff you can do internally that
And even at your border too.
yeah,
right?
yes,
Yeah.
right. But the question is, if in that situation, especially if it's time delimited and you don't know, you're not necessarily in a position to be able to figure out all the different stuff you might be able to do at your border or inside your border. Is the law properly drafted to prohibit you from doing anything outside of the boundaries of your network, with the understanding that network boundaries is fuzzy? Is that the way it ought to be or has to be?
I just think, building off of what Paul said in response to your previous question, I think that the general counsels that I've talked to and members of boards of big companies, that they're concerned, because there's such a long list of things that are clearly okay that are not being done consistently across the board, that their primary concern is making sure we check and really do 1 through 10 of the for sure legal things that we can do. And this is really out on the ledge. And I'm fighting the hypothetical a little bit, but I do think it matters. A, you've already done some bad things if you're at the moment where someone's inside the network. But B, do you have an action plan? Have you contacted the board? Do you have a plan ready for contacting potentially affected users? Can you segregate your network out so that you can isolate the problem? These are all things that are just crystal clear, legal, and not being done in many cases by seriously large companies despite all of the repeated warnings. And so when companies say, or people who want to sell something expensive to companies say, you really need to be able to fight back outside your network, my general thought is, only if you're already killing it on every other front might you possibly need this. And the marginal payoff, it seems to me, is going to be small compared to all of the things you could clearly do with no legal risk that you're not doing.
I mean, this whole, and again, I'm really enjoying, and Bobby, thank you for asking me to re-engage on this conversation. I mean, I wonder if I might conclude, this is only the middle of the panel, but that this entire thing is a failure of communication that connects directly to our conversation tomorrow about how you train lawyers to talk to techies, right? So I wonder if the, you can imagine like a bad skit where it's like what they say and what the other side hears, right? So you can imagine the techie walking away from a meeting saying, "Dear God, my lawyer just told me I can't do anything." And you can imagine the lawyer walking away from the meeting saying, "Dear God, my techie just said the only thing he can do is, launch a nuclear strike at this IP address," when I doubt that's at all what is being said on either side. And so this is a different way of finding your hypothetical. My question for my head of security would be, all right, describe for me exactly why you have the capability to take someone out without, a lot of, downstream innocent victims. Describe why that is true, and we can't just block an IP address or a port, right? Like, I think that's a disconnect, and if someone in the audience has an actual hypothetical where, those two things are both true, I desperately want to hear it. But my response would probably be, Richard, we've talked for you the entire time, by the way.
I apologize.
Yeah, and you're going to get more calls about all the policy we just said.
You might want to just pull out your phone.
Yeah. But I want to hear that scenario, because I actually don't think that scenario exists. I'm becoming quite, incredulous. Yeah.
I really wish that HD was still here.
Yeah.
Because I think that he would have, we're talking sort of in a little bit of a emptiness
Yeah.
of what the technical details are, and I'm going to be guilty of that as well. But in the course of an investigation, if you've ever counseled a client who's gotten hacked, there's all kinds of things that come up.
Yeah.
Like, how do I find out who it is?
Right.
So I can sue or whatever I
Right.
want the government
Sure.
to prosecute.
Yeah.
They stole my files. Can I go steal them back? Can I track where my intellectual property is going and that sort of thing? So I don't actually think it's a technical misunderstanding.
But that's not what Eric was saying. Eric was saying they're
yeah,
going to
I
exfiltrate all my data, and I know it's right about to happen,
Yeah.
and the only way I can stop it is to take them off the network.
Yeah,
That's the one where I would say, I don't believe you,
That's
right?
cowboy talk.
Okay.
And there I totally
Okay.
agree. That's just cowboy talk.
Yeah.
It's sort of like
But if you bring it to attribution or deletion,
yeah, I mean, there's obviously some stuff, and talking about protecting yourself, you should be able to do that on your own network.
Okay.
If you're talking about like investigating,
Yeah.
Stealing your data back, like figuring out who it is, whatever that is, well, that's a different thing, and that's really not your role as a private company. You have other things that you can do, and then if the government's going to get involved, the government has process that it should follow in order to collect that
Let me just do a quick loop finger. Let's say hypothetically, it's a law firm. Hypothetically, they realize that they passed the material extracted from them. They realize it's very sensitive client material. They have a very skilled IT individual. IT individual is able to start to trace back, traces it back, and then finds the material back on a foreign server of a foreign power. And as it comes to the managing partner and says, we can go to Sloan Carlin, get Carlin to help us. This appears to us to be an international event. Talking to Sean, but I would like to remove that material off that server right now.
The hypothetical is hard to believe because I don't know a law firm with a highly skilled
And I will say you're young.
I'm just kidding. I'm just kidding.
There's certain law firms that have.
I'm kidding. I'm kidding.
Well, but that's not the same
That's
thing.
what it is.
That's not the same thing, right?
So, what would be the reaction of the panel?
Yeah.
And what would the managing partner fear? He would potentially notify NSD, and NSD would say, what do you want us to do? We can do an investigation, we have new powers under the new executive order, we can try and freeze accounts. But we're talking about months and months of activity versus we have responsibility, we have this material, we know it's gone, we see it, we can go in there and we can test it. We may cause third-party issues, but our problem as well, so be it. What would be the panel's reaction? What would be the hypothetical?
So I'm late to the game. Let me, first of all, apologize again. Emergency came up, so I was very loath not to be here for this. And I also am at a disadvantage because I haven't heard.
Was it a law firm who called though, by the way? No.
The only things you've missed are that general disbelief in the need for active defense beyond the confines of an owner's network, and also that DOJ needs to provide more clarity in terms of what's permissible under the law.
So I 100% agree with the notion that the instances when this is likely to come up seem vanishingly rare, but so that we have a hypothetical, and we said this is in fact the case. I guess there are a couple things. One is, I'm not sure that I would concede that there is nothing that can be done in the government support route. Depends what country it is. It depends on a number of factors, but we have rapid response capabilities, especially with reasonably allied states. The other question I would have is, from a strict legal point of view, we can certainly talk about whether this activity from your fellow would be a violation of U.S. law. I think it would be. And whether it would be a violation of the other country's law, which I think it would be. And so, it's one of those dicey things where we can weigh the risks or the costs of damaging this other system, and then maybe the law firm's willing to take those risks because the downside of being exposed for the fact that you've lost your client data is so horrible that you're willing to take that risk as well. But that guy might well be in trouble when he goes on vacation to France next. I mean, no kidding, these are violations, and the other country may not treat it in nearly the same way that we think we.
Is it Coke?
An example is China, and it's sitting on a government website. It's sitting on a government data.
So
That's military related.
let me buck the hypo. The odds that you're going to be able to isolate it and be sure that you're getting the thing that you think
And
you're
the
getting
only copy of it, right?
What are you
are
getting?
vanishingly small. So what are we talking about? Then if it's China, let me add one more layer to it, which is foreign relations is something that is granted to the power to the executive here, and for a good reason. You can sort of imagine the idea of your Sony hacker, Sony hires somebody to go back against the North Koreans. I really think that's not the kind of world that we want to live in. There are good reasons why you need to have somebody at the helm who's making the call and thinking about the geopolitical situation and not just having everyone go to town on what they think is best for themselves, because the risks that something will be misinterpreted are potential and not something we really want to tangle with.
You understand the frustration in the private sector?
Yeah.
in these
Yeah.
scenarios,
Yeah.
Sure.
and
Absolutely.
there's a deep frustration.
It's funny when you gave the scenario, the joke I was making about IT security, I was actually thinking of a very similar scenario where, Coke, about the Coke juice deal? I mean, so Coke was thinking of acquiring a juice company in China, and the group of Chinese hackers hacked into the law firm to steal basically the negotiating documents and discover the position, how much Coke was willing to pay for the juice company, and effectively that changed their bargaining position, and the deal never happened. Why did they take it from the law firm? Because they couldn't get it from Coke. So the law firm was the weakest point in the network that contained documents related to the deal. So A, worry about law firm security as much as corporate network security. But B, what are they going to do? They're going to hack back into the damage is done the minute the document is seen. So they might start a war with China, which would be really awful. But even if they don't start a war with China, what's the gain in going back and attacking the group of lowly paid Chinese hackers that got the document?
So you change the hypo turns on an information issue for the deal
Yeah,
versus maybe proprietary information from certain other element.
right.
But as you said, it was, that issue is also example is, we've talked about in the ABA, so does that mean law firms should be keeping multiple documents with multiple possible
Yeah,
numbers?
yeah.
So you create your own multiple different denominator sections inside your own system.
Yeah.
So when you pull it, they go, what am I do? I see 5 numbers there.
Yeah.
And you go, yeah, you have 5 numbers, but only 2 of you can know what the actual element number is. Should that be a new ethical requirement based on the ability of the systems in IT? Because you understand from a legal perspective,
Yeah.
how you do the ethical code issues, and how do you put that on the law?
I don't know about ethical requirement, but I've talked to a bunch of people who agree that that's an underused tool, that you can make it a lot harder for someone to suss out one thing to take if there are 3 things that all seem plausible. And of course, the negotiators in the firm know which one is the real one.
I don't want to leave the discussion of hypotheticals prematurely, because there may be some more utility in having that conversation, but I do want to circle back to the point that I think Paul made at the very beginning about, or maybe it was Andrew, about the desire for greater clarity from DOJ. I did my best to answer that question, Richard, but not in a way that I'm sure you would have found satisfactory. So I'd like to turn it over to you to talk about the ways in which DOJ maybe is thinking about of trying to clarify authorities or boundaries for private parties, if at all.
So maybe I don't have quite the same framing here of where the gaps are in people's understanding. I guess I sort of view these sorts of situations, though, as closer to the heartland of 1030 offenses. That is, accessing without authorization to obtain information valued at X amount of money, or causing damage, which means destruction or harm to the integrity or availability of a system, and having one of the aggravating factors in it. So maybe I'm not tracking exactly on what the concerns are, but it seems to me these are fairly clearly, at least the hypos that we're talking about here, fairly clearly inside the scope of 1030. And so I'm not sure I think that I'm not sure I understand what the gap is. Interestingly, in the CISA bill that was recently passed, there is a discussion of what a defensive measure is. We already talked about it, okay.
Yeah,
All that's to say that this is in some ways a gloss on the very thing that the criminal statute prohibits. And so talking about things that provide unauthorized access to, substantially harm, or render unusable or destroy, well, those are the activities that are going to be covered by the statute, and they're sort of reiterated here as part of the recent legislation. So if somebody wants to pose the edge hypothetical, and I can take a swing at trying to tell you what I think, but I guess I don't know that there's a lot of effort to try to figure out ways to clarify this particular area of 1030 not being the most clear statute, and I think it is indeed in need of reform. But for the multitude of policy reasons why it's a bad idea, I don't think that there's a lot of striving to figure out a way to make it possible when I think there are so many good policy reasons why it's not the direction that we should be going.
Do you think it is fair to characterize the CFAA as authorizing almost anything that you do on your own network and prohibiting almost anything you do on another network without consent?
That's probably not a bad 30,000-foot view.
Yeah.
Yeah, that's.
So, and the question that what we were kicking around before you came in was the question of if you are you look at a parallel to the realm of physical security and the fact that there is a fair amount of self-help available for private individuals and entities in defending themselves when law enforcement is not available, when it is done in a reasonable manner, and when it meets various common law tests. Do you feel like there is any room for that in the CFAA?
I guess I think there's a pretty big difference between self-defense in a physical encounter with someone and what amounts to retrieving your property or punishing someone who did something to you. Those are kind of different concepts, and we don't generally accept the idea that if your neighbor steals your television, that you're allowed to break into his house and get your television back. That's actually, I think, probably broadly not what we think is a good idea. Depends if it's cattle or not.
Things are a little different here.
You have to shoot your neighbor. Actually.
Just go. Shoot.
You have to, right? Yeah.
That's how you get a television.
So in the same way, we also don't permit you harmed me yesterday, so I get to go harm you today. Also, in this context, that doesn't make any sense. You don't get to strike back just to cause harm to someone who's harmed you. That's what government is for, the monopoly on the use of force.
But there are, in the physical realm, instances where individuals are allowed, even in some cases explicitly authorized under statute, where self-defense is actually baked into law, and in at least with respect to assault, battery, murder, I don't think there's a jurisdiction in the country that would say that no common law defense is available. And so I guess the start question is, even though yes, you can paint a scenario where there are all sorts of unreasonable things people could do in the physical or cyber realm, is that kind of common law defense simply unavailable for the CFAA, or for a policy matter, should it be unavailable?
Well, I've already answered that
Yeah.
question. so
Oh,
I think
we're
he's
coming
asking-
back to
yeah.
me?
I think he's
Yes,
asking
yes.
you.
I actually don't know the answer to, as a strict matter of law, whether it's the thing. I suspect it's not, but I guess I haven't delved into that.
Yeah, at least in my read of the CFAA, there's no explicit mention one way or the other on this topic. But again, that's also the case in other statutes where, at least based on precedent, it clearly is available.
I don't recall having seen that come up in any case that I've read about this idea of a common law defense in a hacking case.
So then let's, I think, maybe shift to talk about the idea of civil remedies, which is something we've touched on briefly. And I think, Richard, just before you came back in the room, we were talking about whether there's any utility in drawing distinction between a defensive measure and a measure that is designed to gather information about, an assailant, a cyber assailant. But the civil remedies that are available, which, in the discussion from the last panel, there was some criticism about the impact that has on security researchers. But that notwithstanding, is how much can be done in the realm of advancing the availability of civil remedies? Is there either a role of government in trying to encourage that? Should
Wait, who's suing whom in this?
it would be a
The victim
a
suing
of
the hacker.
cybercrime suing the hacker.
I see. Okay.
With the understanding that many hackers are outside the United States or make it very difficult to determine who they are, where they are. But this is precisely. But you can still have a lawsuit against a foreign litigant and gain injunctive relief. You can put a judgment over their heads that can make life very painful for them, even if they're not inside the United States. Sure. So is that one of the vectors that we should be encouraging individuals and organizations to pursue?
I mean, I'm happy to give Richard a second to think about it.
Yeah.
I mean, you know, I, like most academics who think and write about the CFAA, kind of abhor the civil remedies. They've led to nothing good and mostly bad. They've screwed up the case law. They've seeded, you know, sowed confusion about what these words mean. They've opened up the door to expansive prosecutorial discretion. And if we could get a Congress that passed legislation, that's one thing they should clearly fix. However, in a world where it exists, then absolutely, you know, if you know, attribution's a bitch and it's gonna be hard to know who to sue, but if you can find the person who's caused you harm and Congress has given you this tool, then yeah, I hope you can use it, right? And I don't, you know, I mean, and maybe it'll let you use civil discovery tools to learn things. Maybe it'll, I should know the answer to this. Maybe it'll let you use civil seizure provisions to get additional remedies, injunctive relief. I mean, yeah, you know, that's a tool in your arsenal. You might as well use it.
Yeah, and maybe it'll have a form of deterrence for
Yeah.
other cyber actors. And somebody alluded earlier to the cyber sanctions executive order, and I think using those OFAC tools is another
Right.
potential, you know, tool that could be used to identify people and then as a form of deterrence for future action.
I guess I would say, I think many of the points that you guys just made are very valid, and I don't have a sort of cleared administration position to share with you about whether we should or do away with that or not. However, I am also sensitive to the points that were made on the previous panel by Jennifer regarding some of the difficulties that the civil provisions have made in the context of security research. So I think looking at that question as well and how it intersects here, maybe these cases are more clearly actual, as I said, heartland to 1030 types of offenses where somebody's literally breaking in through some security vulnerability from another country. On the other hand, I do wonder about some of the attribution and the problems of attribution and the problems of deep pockets. These are probably shallow pockets, and I'm not sure how you're going to get your judgment at the end of the day and stuff. Maybe there are certain cases where the person is a disgruntled ex-employee who is in the U.S. and actually can be gone after in some meaningful way. Maybe. There don't seem to be that many of those types of cases out there, but there probably are a few.
Are there things that the government can do to try to encourage this? And, you know, I'm thinking about, for example, not to intrude on the botnet discussion, but you know, I think that Microsoft is certainly the one company that has explored civil remedies more aggressively than any other company. I'm not sure there is another company that has, at least under the CFAA, under the CanSpam Act, Facebook has you know, gotten $100 million judgments against spammers, you know, at least one of whom was in Canada. But I guess the question is, do we want, I think I know Paul's answer to this, do we want to make it easier for private litigants to know what remedies are available under these provisions of the CFAA, for example, because it seems like the only ones who have been willing to avail themselves of it are the people with the very deep pockets, who are granted going after people with shallow pockets, but in a way that I think to them is both stopping some malicious actors and deterring others.
Yeah, that last bit is what would be my main question. I agree completely with Paul that whenever I hear the CFAA, the first thing I think about is Aaron Swartz, and so it's hard to take seriously the idea of expanding incentives for prosecutors to use the statute. But you know, maybe if we're on the cutting table and we're fixing the whole thing, maybe we define it in a way that's more tailored and can't be used in such a broad way. But I would wonder not about the ability of someone to collect their money, to recoup the sort of restitutionary aspects of any kind of remedy here, but rather the deterrent effect that it would have. And I just don't know, even if Facebook ultimately collects $100 million from some spammer, does it make an effect in the spam market? I have no idea. I suspect that it doesn't, and that spam carries on, and that the things that stop spam are better filtering technologies at the companies. But that's an empirical question. that, again, as an academic, I don't know the answer to.
Other thoughts? What about the idea that Department of Justice could, as they have done in some cases, pursued civil remedies as opposed to criminal ones when going after people who violate statutes like the CFAA to kind of pave the way and provide a leading example for other litigants so that they at least know what the scope, or have a better understanding of what the scope of remedies are that are available?
Well, the department has used civil remedies in one particular instance, which I think has been pretty effective and that I think we are going to hear more about in the panel following this one, which is the use of civil remedies as part of an effort to take down a botnet or other widespread code. And in those circumstances, I don't know about leading the way, but we think it is an effective means when you need to have court authorization to do certain types of technical acts which will stop the botnet from working. And having that court intervention, I think, is a very useful thing to, on the one hand, comply with the law, on the other, make sure that we have judicial oversight, and thirdly, to be able to compel certain types of activities by others in the ecosystem to be able to effectuate what's going on with the botnet takedown. So, for example, a domain name registrar relinquishing or repointing the resolution of bots as they phone home for instruction. So I think in that instance, certainly that's there, and making sure that that is a clear authority, I think that's true. Broadly speaking, though, I don't know how useful it is for the department to be bringing civil suits against hackers when we have a criminal remedy that's actually likely to be more effective. That's going to be the one that we're going to focus our energy on more than it is bringing suit in a civil context.
And then I think one of you, since you mentioned the botnet takedowns, there is a fair amount of collaboration that has happened with the private sector in some of those cases. I guess the question is, how much more of that do you guys have the resources to do? And maybe I can, ask Sean to weigh in on this. Like, that's I think that those are success stories. Is that something that a model that can be replicated not just in the arena of botnets? Can you go farther to essentially demonstrate that, hey, there's a lot more that we can do that doesn't involve people hacking into other networks?
I think there is more we can and should be doing. I think the biggest thing the government currently struggles with in dealing with the cyber problem is trying to figure out how best to measure success. And as you alluded to, are these things that we're trying to accomplish, are they actually having the return or disruptive effect we're planning for? So we can certainly use legal tools to effectuate botnet takedown. But what are the things we're not doing that maybe we have parallels for in the physical world? Are we taking advantage of, even though some of this is controversial, some folks in different respects, asset forfeiture type provisions where we're actually going out and either grabbing the stuff that's being used by the actors and just start dismantling more of the actual infrastructure that's being used. But again, that gets complicated too because a lot of these actors are not on, they vary between using compromised machines as well as things that they're leasing or legitimately have on their own. So when you start running that space, it gets back to the issues with, it's not so much that the tools, I think, are lacking or that we don't have desire to do more of it. It gets back to the issues about attribution, identifying, having partners in the private sector and other government agencies and globally to help do that. These are, when we have done these things, they've been relatively successful. It's difficult to do it in a scalable fashion. It's not as simple as just rinse and repeat. It's not a great answer, but that's kind of
So in short, yes, we want to do more of that, but there's real limits on how much can be done?
We have to get better, we have to get faster, and we have to figure out what are the, I think it comes down to resource allocation, finding out what is that sweet spot of, these are things we can do, and these are things that are gonna have the effects we desire, that we're hoping for in having this problem. I don't know that we've developed a fulsome strategy to really have an idea of what that is and what that looks like.
Yeah, but I'd hope that the federal government would see the fact that companies with the information that they have in the cybersecurity domain, both in terms of, experts, in terms of technical expertise, in terms of, network monitoring that they do, that in contrast to, say, counterterrorism, it really should be a true partnership between the public sector and the private sector. And so, you know, the government benefits from those public-private partnerships as much as vice versa.
Yeah, and we'll probably talk a little bit about this next.
Yeah.
The FBI, especially over the last couple of years, has really tried to enhance its public-private partnerships and information sharing as well as coordination to effectuate things. Because frankly, from a legal perspective, a lot of these things that may be beneficial to cybersecurity and accomplishing some of these goals may be easier for our partners in the industry to pull off.
Yeah, and with the recently passed legislation, that potentially reduces some of the,
When you say asset forfeiture, and I think about attribution problems, I see the photograph of FBI agents walking into a public library to take the computers.
That's not the picture I wanted to be.
I know.
We're gonna do that at night.
Yeah.
I think we can be more nuanced about this idea of public-private partnership in a lot of ways, and we're gonna probably get into it in the next panel, so I don't wanna get too much into it. But I do wanna say that I think there are some security challenges where government participation or assistance is clearly gonna be something that is useful. Maybe that's botnets, maybe it's not, maybe it's attacks by nation states. But, you know, I as the taxpayer really don't want my money going to help companies who don't make the security investment in the first place. And I don't really care how hacked they are. So, you know, we can look at Sony, for example, and, you know, there's this big idea there, like, okay, well, the government should have done more or helped more there. So first of all, who's an American or who's an American company? You know, why was Sony's security so crappy? You know, is the stuff that, the way that Sony's harmed a public harm, or is it a private person harm that we as a community should be involved in? And how much money do I want to pay? Because Sony didn't pay any to do the basics.
Sony's too big to fail.
So, yeah, well, I mean, right, exactly. So, I mean, there's obviously going to be areas where this is a law enforcement responsibility, but I think there's very clearly going to be some attacks and instances where it's not law enforcement's problem. And I don't think it should be law enforcement's problem, and it's the company's business to fix it.
Yeah.
I mean, I think corporations also have the right to have access to law enforcement to protect them. You know, they're
Yeah.
citizens too. I don't believe the Constitution makes there's no differentiation in the Constitution if you're a real person or a corporate person. And the reality is today, you know, I don't work for Sony, you know, but I probably own Sony shares. You probably own Sony shares in some Vanguard fund. So there is a public interest for others other than like the CEO of Sony for law enforcement to protect Sony, notwithstanding the fact that they may not have the best security.
And there's also clearly a public interest for companies, you know, where the impact of an attack potentially has a broader impact than just the company in terms of critical infrastructure, other things where there's potential for harm or physical damage.
When my car gets broken into in San Francisco, and I call the police, they don't come. When they do come, they say, did you lock your car door? And if I say no, then they turn around and they go home.
Right.
They have a limited amount of resources. And we as, you know, it's like,
But now you're looking
I'm
at-
the victim, but I have a responsibility as well.
Let me give another sort of hypothetical. Another hypothetical is you're a company that produces academic journals and papers and books.
So, very profitable company.
Yes. High stakes.
I would say to you that it's a company that is involved in a professional area as opposed to what you guys do, so you're sort of involved. Let's say it's around a couple $100 million business. And what happens is the universities have situations where people are spoofing and asking students. They go up into the academic library, they pull down all of these articles, and then the articles seem to appear on a news site in Russia. And we're talking about millions of articles, hundreds of thousands of articles. It's been like an open sieve. And what's happening is people are now going on to those those sites they don't have to pay.
And they're learning things.
And they're curing diseases in their
Yeah.
small villages.
Yeah, yeah, yeah.
This is a horrible story you're painting here, right?
Really upset about it.
People can use conservative the most of Moran.
Right.
The scientific journals that people really find fascinating.
I think you need to pick something. If you're trying to pull on our sympathies, you're picking the wrong example.
Especially considering.
It might be JSTOR, but I mean, what you're talking about.
So let me just lay it out. It's not.
We should have censored
So
the
the company,
articles.
well, the company is now losing $4 million a year.
And they also this is a bad example. You're pushing on.
Let him finish.
Well, from the company's perspective, they did everything they thought was right. The universities have horrible security systems, which is allowing them to go into school.
Universities have open networks and academic freedom. That's not quite. This is why I'm just saying you're inviting a different kind of fight than the one I think you were. Yeah.
From the company's perspective,
Yeah.
that has been up and going concern for a long time.
Yeah.
They basically confronted with this set of problems.
Yeah.
Go to the government said the file suit, and last, it was gonna happen. But leading every day, long-term, and by the way, if I was advising the Soviet Union, New Russia, I'd say, why not just leave the American entire publishing industry, drop by drop? It's the government's, your reaction is what we're gonna get, exactly.
Yeah.
And we can slowly start going after their entire
Yeah.
publication set of industries, drop by drop. Because you're actually exactly like.
I want to be nuanced about my response just because I don't want it to be mischaracterized, right? So you're talking about an industry built on extracting wealth from scientific knowledge, probably charging the professors to publish. It's just using intellectual property law in overly aggressive ways, catering to the open academic community, and yet blaming them when they have poor security. My point is, you couldn't have set up a worse hypothetical for raising complicating factors for a relatively clean and narrow point I think you're trying to make, and an interesting one. But I feel like this is a particularly bad example. Yeah, yeah,
Many of the faculty,
yeah,
that you said were properties, they're so happy someone is reading them.
yeah.
Yeah.
That's my point.
They want those journals to go out of business.
Yes.
You guys are so easily purchased for
Oh.
copyrights, for because it's all about when you think of what you get for your research. You write academic books.
Yeah.
But from the company's perspective,
Right.
and intellectual knowledge that the books get set up, there is no intention.
Don't get me wrong, I'm not an anarchist, but if all journals got replaced overnight with an open source model, we'd probably live in a better world. This is just why I'm saying you picked a bad
Paul,
example.
let's change it to case books. You're working on a book. Now, you may be planning to distribute that free, but you got a lot of intellectual property sunk into that.
everything.
So
yeah,
it's,
I
so
don't
it's
want
your
this
book.
to become a first principles IP debate, right? My point is just, Coke and Pepsi, I was much more comfortable with these examples than intellectual property and academic articles. I actually am not a casebook author, but I've talked about writing an open source casebook where we give it away for free. So, so maybe I am an anarchist, I don't know, but.
Leave Bill out of it.
Well, sure. The earlier actions were taken with being downloaded all over the world.
Yeah.
Yeah, I know, I'm sorry, I
Yeah.
took that to.
Let's bring the conversation back, because I think we've strayed.
Have the knowledge.
Yeah.
They don't make minimum wage on Facebook anyway.
So I actually do, I mean, I know we're running towards the end of our time here, but I'm interested in exploring a little bit further the Sony example that you raised, but I'd kind of like to move away from that specific example but it does raise the question about, you said you have no sympathy for companies that haven't provided for their own defense.
Well, I'm saying, I don't want to overstate it, but yeah,
Yeah.
I mean, that is what I said. But what I meant more was that public resources are not, shouldn't be involved at all, but certainly shouldn't be the first step in something where the private company hasn't taken the basic steps to protect itself.
And there's a moral hazard. We have to draw the line. I mean, I take your point very well, that you have to draw the line somewhere that protects, and I think Richard's point is a good one too. You have to, some companies should get protections, but at the same time, you don't want to protect people who don't take adequate measures to protect themselves.
It's tough,
'Cause
though,
then
'cause we're not going to
everybody's-
know in the front end in many cases what measures they took. And
Yeah.
It's going to take a while to know.
That's true,
And,
yeah.
and it also is a question of who's facing them down, how sophisticated is the adversary. This is
Right,
one of
I
the reasons why
agree.
Sony is a bad example. But this, I think it's interesting because this cuts a couple different ways. Because on the one hand, the question I think you raise is a valid one. Should we be expending public resources to defend somebody who's not defending themselves? If the answer is no, how free a hand are we giving those private individuals and organizations to defend themselves? And are we imposing strict limits, for example, taking away common law defenses from them?
But so you're talking about like a lawyer, which is that you're saying the first stop
This is a
is
curse,
the law.
yeah.
I'm a lawyer too, so I still do the same thing. But the first stop is the technology. And if you look at things like the Council of Cybersecurity and everything, what they will tell you is that companies, they have the 20 SANS things that companies should do to protect their networks, and most companies
here.
Can I circle this back on an earlier point about the depth of emotion about unhappiness and inability to respond, and why hackback is relevant too? It's, I think, a very human and natural thing to say, wait, these people are in my network, what the heck, we have to do something about this, I need to strike back. But maybe that ought to be redirected a little bit to, did we take all the reasonable steps that we should have taken? That would be one question. And secondly, did the software vendors who supplied me with the code that turned out to be buggy bear some responsibility here too? Reaching for a rock to throw back doesn't necessarily seem like the right way to direct those energies.
But haven't we already resolved that question through the carve-out for negligent software designer of the CFAA?
I'm sorry, what do you mean?
There's a carve-out from the CFAA that says that there shall be no cause of action for negligence in the design of software, and that seems to be what you're suggesting, we need to take that out.
No, I'm not talking about the CFAA. I'm talking about the contracts and the torts and all the other things that seem to not be present in our current system of holding responsible the makers of software.
Right. Well, and we have other means through the law in order to go after the people who attacked you. For example, California has a mini CFAA, and it used to be the case that you could not bring a civil cause of action unless the person you were going to sue had already been criminally convicted. And the way that law got changed was eBay sponsored a bill and said, look, we can identify where our systems are being attacked, and we try and tell law enforcement about this and get their help, and they either don't have resources or they don't understand technologically what's happening. We need to be able to take some measure to strike back against them, and so we need to have that criminal conviction prerequisite to out of the law. And that got passed. And that's now law in California because one of these deep pocket large companies said we need to be able to have more of a tool within the civil regime because of the inadequacy of public resources, whether or not more appropriately deployed. You may obviously come and say, look, we didn't do enough for our system, but they got the law changed in order to suit them to broaden what they can do.
I think Eric, you had a question?
The question this time, it's been very U.S. focused, the conversation. Does anyone track this debate internationally? Are other countries having similar policy discussions about what's permissible, what more should be done, so forth?
I think I have a vague sense of what they do in Israel, but it's not necessarily a very close parallel for us. But yeah, oh yes, we have a UK member of the other.
You stumped the committee,
Yeah.
so very nice.
So the Computer Misuse Act in the UK is, I suppose, equivalent to section CFA, which operates in 30. It's pretty simple, frankly. It unauthorizes the important word there, authorized access, authorized, I can't remember what the words are, frankly, but that sort of distinction from inside and outside is pretty simple.
I know the new cybersecurity strategy that the UK government has some language around active defense, but I'm not sure, like, if it's about giving new authorities or what.
So the new cybersecurity strategy is written with us.
It's been
But
flagged.
it'll be later this year. Although the Chancellor talked about active defence in his speech back in May, but that was something, this was not about companies acting back, this was about service providers doing blocking back at the early stages of different things.
I think that's, oh, dude, Greg, you had something?
I was just gonna ask, it just seems to me that we talk too much about the CFAA and not enough about the new legislation.
CISA?
Yeah.
Yeah.
There really is, I'm having trouble understanding exactly what it's authorizing that was prohibited before.
Yeah.
And here's what it says, real quick. It says, if you use a defensive measure, which is an action, device, technique, procedure, or other measure applied to your own data or information system that detects, prevents, or mitigates a known or suspected cybersecurity threat or vulnerability. Those two things are defined terms, or defined broadly. It can't be, though, something that destroys, renders unusable, or substantially harms, or gives unauthorized access to someone else's information system or data. So what exactly are we talking about? It's newly lawful that used to be prohibited. Because a court reading this is going to say, it must mean something. It must authorize something that used to be unlawful. Because you can use a defensive measure notwithstanding any law.
Wait, but I'm not sure I agree with your rule of construction. A court will say, perhaps they put that in there to give clarity to the edge cases, but it doesn't really change in any, appreciable ways what the CFA was doing.
But Paul, what would be an edge case?
Yeah, I don't know, but my point is, clearly, there's a lot of uncertainty among general counsels about what can and cannot be done. You've got a lot of language in there, like own system or data, is that what you said?
Yeah.
That's a lot of clarity right there, right? Thou shalt do no harm, that's clarity. But my point is, you seem to suggest that a judge would say, unless it changes the old law, there's no reason Congress would have written it. But if I'm litigating, I say, no, Congress wrote this because it's a vague, open-textured law.
Providing clarity
Sure.
does change the law. And it makes it so that this other thing that was unclear is now clear.
Yeah, but that's different than what you said a second ago, which is something that was illegal made legal. I'm not sure the law has to do that. Yeah.
Let me just clarify, too. You said Richard, as if my department was the proponent of this. We certainly commented on it as all sorts of players in this debate went on and on. I understand, and this wasn't our equity, that it was recommended by companies and system administrators and their lawyers who were worried about lack of clarity, as Paul says, about what could be done on their own systems. And this creates a very broad set of things. As long as you're on your own system, you can do most anything if it's in the services of computer security. I think that's probably what the bottom line is on that. And the fact that it has this carve out for, and by the way, don't be doing bad things to other people's systems, is important so that it doesn't, in fact, overrule 1030 in its notwithstanding clause and say, oh yeah, by the way, hackback is fine. In fact, Congress said exactly the opposite. No, hackback is not fine, and it wasn't fine before, and this doesn't make it any more fine, is basically the idea.
Eric, does that speak to your common law defenses concern? Does
I-
that actually make it?
No,
more
I don't think it resolves the issue, because because all CISA does is say, here's some stuff that is authorized. It doesn't say, although it does have, reinforces some prohibitions, it kind of leaves the CFAA in the role of having those prohibitions, but still it doesn't say, in my mind, one way or another, whether common law defenses are available or unavailable.
And the definitions and this language only applies really to then the next sections in relation to sharing of information between the public and private sector, and the liability is provided for that. I don't see that it changes the underlying framework for, for the things we've talked about today.
I think that's it for this panel. In a moment, we'll applaud them, but first let me just point out the modified schedule. We're surprisingly close to the actual schedule. We'll break for 10 minutes. At roughly 3:55, we'll conclude today's sessions with our botnet panel. But let's thank this panel very much.